Hi guys, welcome back to this channel. Welcome to the channel. If it's your first time around here, well, do we have some crazy fire exclusive content for you today? I'm sure you all remember this one, this thing here, old Jessica Verbruggen. Remember the old scenario of her being a criminal and taking police chases and blah blah blah, and Uncle Carl, this fella. There we go, guys. Yeah.
Let everyone know what you've done in court.
Yeah, absolutely. We hate criminal convicts.
Yeah?
Yeah. Criminal police are worse than any, aren't they?
Are they?
They are indeed.
You're like lectures, aren't you?
Yeah, absolutely. When you're recording a video, you should do it in landscape, you get a better reach. Yeah? Carry on and I'll have you rejected from the court, alright? Carry on. Carry on. This is my job, you muppets. Get in there and shut up. Thought you were all clever, family of Wronguns it were, it turned out. I will drop the links to the previous videos if you have not seen them before. But here, I have for you the 100% in full police misconduct hearing. Yeah, I will admit, I didn't realise it was actually going to be a video conference that I could watch. So the first about 11 minutes, you can just hear the voices. And then I realised that there was video to be watched as well, so I do apologise for that. The sound quality isn't all that the best, but you can make it about 95% of it. That's just their crappy software that they're using.
Right, good afternoon everybody. This is an accelerated misconduct hearing being held on Tuesday the 1st of October 2024 at Unit A Central Park, GMP Force Headquarters. The time is now a little after 2 p.m. I am Stephen Watson, the Chief Constable of Greater Manchester. Could I ask those people here present and involved in proceedings, please, to identify themselves and their roles for the benefit of the court? We'll start with you, Mr. Match.
My name is Gareth Matchwick. I am the solicitor that is presenting the case today.
Thank you.
Also, I'm DC Chris Nicholson, the investigating officer for professional standards.
Good afternoon.
Good afternoon, sir. I'm Sergeant Tony Dixon. I'm proceedings officer.
Thank you very much. Okay, the purpose of this hearing is to search for the truth in a fair, objective and impartial manner, not designed to be adversarial. I'm sure that I can rely on all parties to assist me in this matter. I can confirm that I've considered all the papers forwarded to me. I'm assuming that those representing the appropriate authority have all of the relevant documentation. I do note that Ms. Verbruggen has confirmed to the MPU that she does not intend to engage in these proceedings, and therefore no person will be attending on her behalf. I have seen that. The purpose of this accelerated misconduct hearing is to provide former Constable Verbruggen a fair opportunity to make her case, having considered the investigation report, including supporting documentation, and to put forward any factors the officer wishes to be considered in mitigation. As I've already noted, Ms. Verbruggen is not here present today, has not put forward any information or material going to mitigation. She has confirmed summarily to those representing the appropriate authority through a representative of the Police Federation that she does not intend to engage in these proceedings. Secondly, the purpose of this hearing, therefore, is to determine if the conduct of former PC Verbruggen amounts to gross misconduct, and if so, to determine what the outcome should be. In deciding matters of fact, I must apply the standard of proof required in civil cases, that is to say, on the balance of probabilities. So unless there is anything else, I propose to commence this. Thank you. So in respect of the allegations that would have been put to this officer had she been present, the history of this matter is as follows. Former Constable Verbruggen joined Greater Manchester Police on the 13th of March 2017. She resigned her position as of the 12th of May 2020. On the 15th of June 2023 at Leeds Crown Court, Ms. Verbruggen was convicted of 2 counts of committing an act or series of acts with the intent to pervert the course of justice, and 2 counts of causing a computer to perform a function with intent to secure or enable unauthorised access. Convictions related to the following course of conduct. Between the 28th of September 2021 and the 2nd of November 2021, Ms. Verbruggen completed notices of intended prosecution, falsely naming a person who was not her partner as the driver of her vehicle, which had a tendency to pervert the course of public justice. On the 3rd of November 2021, Ms. Verbruggen made a false report to police claiming that her vehicle had been stolen, following it being driven by her partner and resulting in a police pursuit. This similarly had a tendency to pervert the course of public justice. On the 5th of October 2021 and the 3rd of November 2020, Ms. Verbruggen completed checks on the police national computer relating to her partner, such that she caused a computer to perform a function with intent to secure and enable unauthorised access. On the 5th of February 2024, Ms. Verbruggen was sentenced to a sentence of 18 months imprisonment, suspended for 18 months, 100 hours of unpaid work, and rehabilitation activity requirements for a maximum of 20 days. In terms of the particulars of misconduct, therefore, it is alleged that former Constable Verbruggen has breached the standards of professional behaviour, in particular the standards of discreditable conduct, in that her convictions for the offences of this nature, individually and or collectively, are incompatible with the role of a police officer, bring discredit on the police service, and undermine public confidence in it, and honesty and integrity, that her convictions for offences of this nature, individually and or collectively, show a lack of honesty and or integrity, in that she actively provided false information to fellow police officers and staff. Had Ms. Verbruggen attended, I would at this juncture asked her whether or not she accepted that her behaviour amounts to gross misconduct. She has given no such indication, as she is not therefore in attendance today. I must therefore determine the issue on the basis of the evidence available before me today. This evidence I have presented to me by the authority. Can I ask, Mr. Magistrate, please, that you set up the case against them?
Thank you, sir. You have already outlined the pertinent facts in this case that are contained within the regulation notice. The AA submits that the evidence is clear and uncontrovertible. The officer has 4 convictions against her name, 2 for perverting course of justice, 2 for unauthorised access to a computer system, which was in the event a police computer system. Any convictions are serious, as you know, sir, and that seriousness is, in the appropriate authority's case, sufficient to bring this within the ambit of gross misconduct. In addition, the nature of convictions for perverting the course of justice and misuse of police systems are both serious matters, as detailed in the guidance on outcomes of police misconduct cases, and they further would justify a finding of this gross misconduct. I don't think I need to take you further on this, sir. One point I possibly should have confirmed at the outset, sir, is in terms of if you agree that this case can go ahead as the appropriate authority, and also have today in respect of the time given the collective notice that was sent on 24.
Yes.
I assume so.
Yes, thank you for raising that. I did notice. I am content. I think that those correct notices were issued in time, and I know that the officer was satisfied with the same. I'm more than content for matters to proceed in that course. Okay, so obviously I have considered the paper file submitted to me prior to this hearing. I hear the case of the appropriate authority, which essentially turns narrowly but nonetheless very impactfully on the existence of criminal convictions before Leeds Crown Court. And it is on that basis, and having fully considered all of the information, both within the bundle and that presented in this hearing, I am satisfied with the balance of probabilities that the officer's conduct has failed to meet the appropriate standards and breaches up to gross misconduct, and that is to say, both in respect of credit conduct and honesty and integrity. Therefore, all that now needs to detain us is to determine outcome. And again, one day I might revert to you, Mr. Matrix, such that you might make any representations that you have in respect of outcome, please.
So you have a note. I'll ask you briefly two aspects of it. You, in all cases, have to determine the seriousness by reference to culpability of aggravating and mitigating factors. The AA submits that this is a case in which the officer is highly culpable. The convictions in question represent deliberate criminal acts. The officer appears to have planned a course of action to ensure that her partner was not identified as the driver of the vehicle. Convictions are always serious, as detailed in the guidance. And again, the nature of these convictions, I will repeat the point, are particularly serious given the specific guidance on honesty, integrity, and access to these systems, all of which are serious matters. The appropriate authority submits that in terms of the honesty aspect, the fact that the officer gave incorrect information in relation to a intended prosecution causes this matter to potentially rise to the level of racial dishonesty with a bad impropriety. In terms of path, the appropriate authority refers primarily to the public trust, the risk of public trust in the police, if the public was aware of the conduct. The officer's lack of integrity offends against the good order of the police and the trust that the public should be able to place in police officers. There's also a risk of harm to the course of public justice by the nature of the officer's actions, and also there is potential harm to, and it's not come to light, potential harm to a potentially innocent person who may have been implicated as a result of the officer's actions. In terms of aggravating features, the appropriate authority notes in particular, the officer took deliberate steps to commission the offences. The entire nature of the officer's conduct was to conceal wrongdoing by another person. There was repeated behaviour across a course of time, like where several offences being committed along the same lines. The AA cannot point to any mitigation it is aware of the officer's part, and the officer has submitted no mitigation towards. So when the evidence is considered, we would urge you to find that the officer should have been dismissed, where he's still serving, and so should be placed on the culture precinct's barred list. That is the only outcome that the AA submits would be sustainable in this case, unless I can assist you any further, sir.
Thank you, Mr. Nadrick. I think not. I'm sufficient. I will adjourn briefly to consider the outcome, and will reconvene as soon as possible. Thank you very much. You can be seated. Okay, the time is now a little after 2:30. We'll recommence. This is in respect to former PC Jessica Verbruggen. I today conducted an accelerated misconduct hearing at Unit A, GMP Court Headquarters, and have given consideration to various breaches of the standards of professional behaviour as pertain to former PC Verbruggen. Ms. Verbruggen was not in attendance, nor was she otherwise represented. Ms. Verbruggen gave no indication as to whether she accepts that she has breached the standards of professional behaviour, namely honesty and integrity and discreditable conduct. I have, however, found that breaches alleged are proven and that they do amount to gross misconduct. In coming to a determination as to the most appropriate outcome, I have taken cognizance of the submissions of the appropriate authority as contained within the bundle of evidence submitted to me prior to this hearing, with elements of the same being amplified in inviting verbal submissions by the representative of the appropriate authority. Mr. Madrick, in determining the appropriate outcome, I have had regard to the relevant provisions of College Policing's guidance on outcomes in misconduct hearings. I recognise that it does not automatically follow where breaches of the code of conduct are found to be so serious as to justify dismissal. The dismissal can be the only sanction applied. Nevertheless, it remains very powerfully the case that the principal objective in the conduct of these hearings must be to preserve misconduct found. It is a matter of fact that Mr. Verbruggen at Leeds Crown Court on the 15th of June 2023 was convicted of 2 offences of committing an act or series of acts with the intent to pervert the course of public justice. Mr. Verbruggen was additionally convicted of a further 2 offences of confusion misuse. Circumstances surrounding the convictions related to the making of false reports and seeking to disguise the criminal conduct of her partner in relation to motoring offences. Her actions including the making of false reports to the police, both in respect of notice of intended prosecution returns and in falsely reporting her vehicle as stolen. The misuse of the police national computer was similarly related to her partner's misdeeds. On the 5th of February 2024, Mr. Verbruggen was sentenced to 18 months imprisonment, suspended for 18 months, 100 hours unpaid work, rehabilitation activity requirements for a maximum of 20 days. Mr. Verbruggen resigned from GMP on the 12th of May 2023. In turning to outcome, in considering the appropriate disciplinary action to be imposed, I received written and verbal submissions from the appropriate authority. The appropriate disciplinary outcome, had the officer not resigned, would have been dismissal and placing of the name on the College of Policing's bar list. In determining the appropriate disciplinary action, I have had regard to the relevant provisions of the College of Policing's guidance in this matter. At the forefront of my mind has been the purpose of misconduct hearings. These are expressly set out in the College of Policing's guidance. Assessing the seriousness of misconduct, I find that Ms. Verbruggen's culpability must be regarded as very high. She stands convicted of a serious criminal offence, which by definition amounts to dishonest and malign conduct. With regard to the aggravating factors set out in the College of Policing's guidance, I repeat my comments as to the fact that Ms. Verbruggen now stands convicted of serious criminal offences. Ms. Verbruggen, then holding the office of constable, failed to live up to the responsibility imposed in her. Misconduct involved a course of conduct which was clearly designed to deceive for an illicit purpose, namely the concealment of wrongdoing by another. As such, misconduct was planned, deliberate, and carried out in the full knowledge that it was unlawful, unwise, and indefensible. With regards to harm, the harm to the reputation and standing of the police service, I beg your pardon, is very evidently established. By their very nature, Mr. Verbruggen's offences pose a risk to the legitimate and fair course of public justice. At a time of heightened public concerns surrounding the professional conduct of police officers, this matter falls squarely into the context of things likely to further diminish public confidence in policing. With regards to mitigation and the factors set out in the College of Policing's guidance, I have taken into account Mr. Verbruggen's personal. I am, however, unable to find any mitigation in this matter whatsoever. In conclusion, the level of seriousness in this case must be assessed as very high. Verbruggen's conduct was unlawful and clearly reflective of her being unsuited to the office of constable. The misconduct has cost her very dearly and serves as a salutary reminder of the consequences of failing to perform to the standards rightly expected of police officers by the public. Her disdainful approach to this hearing, which amounts to unapologetic contempt, further illustrates her unsuitability for the role of police constable. Both the public and GMP are well served by her having been forced out of the service. Had Ms. Verbruggen not resigned, I would have had no hesitation in dismissing her from the service. I order that Ms. Verbruggen's name be added to the College of Policing's bar list, and this then today concludes our hearing. I thank all here present for your assistance, and I will ensure that a written record of my determination is shared with you shortly. Thank you.
So, if you didn't get the end or the gist of that, if she hadn't already resigned as a police officer, she would have been fired on the spot for her criminal actions. Guys, again, like I say, if you haven't already seen the previous videos, link is in the description below. Go check it out. And as always, until the next one, stay safe, peace and respect.